And this is a discussion. This is not a formal hearing. So please contribute when you've got something to say. The worst thing that could happen is for us to finish a couple of hours of this and you walk out of this room saying, boy, they need to know this. We are here to listen and learn and not to pontificate. So I'll start with a few questions and then I'll turn it over to my colleagues to ask some questions, but you should feel comfortable asking each other questions also along the way. Let's start with what institutions are doing now. What I have been surprised about as I really got into the weeds on this is how different every campus is in how they're handling this issue. And that there doesn't, now I know there was I think a very comprehensive set of guidance besides the two Dear Colleague letters that have come out from Justice. The Q&A that came out at the end of April, I thought was remarkable in terms of how comprehensive it was. And to me, it gave a lot of guidance on a lot of different topics. But what I want to try to drill down on today is what are the things that we should legislate about how institutions are handling this? And what are the things we should avoid legislating on? Because not every problem lends itself to a legislative solution. Sometimes we have universities checking too many boxes. Meanwhile, they are not really getting at the essence of the problem, which is how much do students know, and do we have counselors? And is there a safe access point? And have we figured out public safety versus confidentiality? And obviously there is a stress there that we've got to manage. Coming forward is important. Mm-hmm. I mean, I understand all of us have great respect around the piece of confidentiality and that this has to be victim-centric in terms of that decision. But if we are going to provide the exact same remedies to someone who has not come forward to someone who has, then we're going to really work against people being willing to come forward. And if we don't get people to come forward, we're never going to hold these folks accountable that did this. I mean, ultimately, at the end of all of this, there's somebody who's committed a felony.
I think it's really hard, after having done years of my own casework, I think it's really hard for people to understand that victims often in that initial stage right after an assault, I like to call it pushing the walls out. They literally, it's like Maslow's hierarchy of needs, right? There's the safety piece, there's food, there's shelter. If they cannot satisfy those basic needs, victims oftentimes have no way of making much more complex and complicated decisions, like whether I'm going to pursue a civil rights violation, whether or not I'm going to pursue a criminal complaint. And oftentimes they are not in a place where they can actually make and understand the consequences and impact of decisions at that early stage. Why I feel so strongly about confidentiality is that that allows victims an opportunity. Time and space. And one of the things I found out recently is that the military system has something very similar to what the FAQ talks about in terms of restricted and unrestricted.
Correct.
I would be curious to see whether or not there are any kind of statistics within that shows if victims went in the restricted lane first, if after a certain amount of time they chose to go unrestricted and then be more open and file more complaints. I don't know that myself.
Well, we're seeing a spike in unrestricted, but that has been because we took the incredible step that I would love to take throughout the country, and that is now a victim at the point of report gets their own lawyer. So
that's why I was asking
advice
you about
the victim is getting at the moment of report has made a real difference. So I think I don't hold me to this, but I think the increase in unrestricted reports since the Special Victims Advocate was put into place has jumped by 30% in just the last year. So you know, I understand. Believe me, I've had victims that all of us who've handled these cases know how incredibly traumatic it is and how hard it is, and how many victims that I've struggled with keeping in the process when we could get a conviction and they just couldn't do it because of the mental health needs they had. And you have to be very, very respectful of that. I don't want to give the impression, but you know, I also know that for every case when perpetrators get away with it, we're creating more cases. And if we take the position that the criminal justice system is historically bad to victims, then we are giving up on making the criminal justice system historically better for victims, because they are intertwined, and that's why one of the next roundtable we're going to spend most of our time on that. I mean, because I think so often victims hear the horror stories and they don't realize that there are men and women across this country that have dedicated their lives to effectively prosecuting these kinds of crimes and to protecting victims' rights in the process. And I just think it's important that victims hear both of that, rather than, oh, you don't want to go there, you know, don't go there. It's going to be terrible if you go there. And I'm worried that too much of that's going on right now, John.
And I think part of the progression, and you know, you've stated it very eloquently, is that there are now victims advocates in many of our courts, and increasingly in the military, which has, as you've said, accounted for some of the increase in reporting. And so just as a general proposition, do folks here disagree with the idea that we ought to have more victims advocates and maybe even require?
So one idea that has come up that I've had, which I think might be really helpful, is these victim witness advocates are really fantastic resources that a lot of prosecutors' offices are using and DAs are using, and perhaps having every campus assigned a victim witness advocate liaison to that campus. So that way, if a student does decide that they want to pursue the criminal justice system, there's an individualized person who understands the student's rights and needs, understands Title IX, and understands that campus's policies, as well as the criminal justice system. And so that way the student is then introduced to those people who are so well trained, the people who are doing the amazing work right off the bat in the criminal justice system. So if that's a route that they choose to take, they have the best resources available.
That's a great idea. Well, let's talk about resources. The pipeline of these cases, and when you have, I think you said 25 lawyers, Jocelyn, that handle this? 25 lawyers for, I think we have 8,000 institutions. I mean, it doesn't take anybody long to figure out that you all are drinking from a fire hose in terms of the work that is being presented to you. So I'm trying to figure out where these cases are going that you aren't handling, and how are we prioritizing them, and what kind of urgency can we bring to this debate about public resources that are desperately needed for Department of Education, for Department of Justice, and frankly, the grant funds.
But I think more globally, I think everyone at this table undoubtedly shares the ultimate goal of increasing reporting both to universities and, where criminal conduct is involved, to law enforcement, increasing accountability for perpetrators, increasing the protection of survivors, increasing the opportunities for students to feel safe on campus. So my instinct is that the pushback that you're hearing here is about how we best achieve that goal. And I think thinking structurally about it, we don't want to do things that will inadvertently decrease the amount of reporting and the opportunity for both universities and law enforcement to weigh in. So I think, John, this is what you were saying, that I think, you know, OVW's experience, the experience of others in the Justice Department, is that supporting victims and making sure that in the first instance they feel comfortable and supported, and that they can get the services that they need on a confidential basis, may be the key ultimately to increasing that kind of reporting. Anyway, on the resources front, and I'll ask my colleague Allison Randall to respond on the grant funding, but with regard to civil rights enforcement, you know, we do the best we can. We have, I think, extraordinarily dedicated and competent attorneys. There actually, I think, are fewer than 25. At last count, there were somewhere in the neighborhood of 22 or 23. We try to choose our cases wisely. We try to choose those where we can have an impact on practices around the country.
It's very competitive, and we wish that we could fund all of the campuses that are coming forward and seeking our assistance.
Well, we would love the stats on that. The money that you have and the breakdown of where it's going, you know, how many campuses are applying, how many campuses are receiving. That would be really helpful to us, because one of the things we've talked about is more, and maybe even more, some specific grant programs for For example, should a Title IX be required to have training? Should a Title IX coordinator be required to have training? Should the people who are adjudicating these cases administratively, should they be required to have training? And if we're going to require training, now some universities, I would make the statement that they could find ways to do this training without money from the federal government. Well, this has been terrific. This is why I think roundtables are better than hearings. We wouldn't have gotten 1/8 of this information at a hearing, right?
I think this has been great.
It has been really terrific. We've gotten a lot of good information. We've gotten a lot of good ideas. I think the more we do this, the more we understand how important it is that we all keep communicating with each other.